You are with the big story here. I'm Seher Zama. Let's make a start with this big development that has come in from the Supreme Court on Kashmir. The apex court here ordering that all restrictive orders there will now have to be reviewed by the Jammu and Kashmir Administration within a week's time. So this is a lock-in period now. The court, which was hearing a batch of petitions that were challenging the clampdown in Jammu and Kashmir in the past 5 months, the court has asked for all of these orders that are related to this clampdown to be published and added that access to internet is a fundamental right under Article 19, which is the freedom of speech, which is the freedom of expression. Let's get in further inputs. We have with us Deputy News Editor Meenakshi Bhanja from right outside Supreme Court at the Apex Court lawns here. Meenakshi, this is huge of what has been reiterated by the Supreme Court today, specifically with respect to internet clampdown and how it serves against our freedom of expression. But there is still a week's time for this review that has been given, and that could further be extended. This does not translate into immediate relief on ground for people in Kashmir, or does it?
Well, yes, Seher, interesting points that you're right. Immediate sort of like revoking of the clampdown is not what the Supreme Court has touched upon. But the very fact that it has put the state administration under a scanner in itself is a big deal. And the very fact that it has asked for the administration to review all the restrictive orders in itself is something which all the petitioners are very buoyant about, because here was a case, for instance, we are into 150 plus days of internet clampdown in Jammu and Kashmir, and there was no end in sight when the revocation could possibly happen. Now perhaps there can be some semblance of finality to that, given the fact that it is the Supreme Court which is ordering for a review. And not just that, Sir, we are in possession of the judgment of the Supreme Court, 130 pages, which has some very, very pertinent observations. For example, I am reading out from page 128 of this 130-page order, which goes on to state, and I quote from point C of today's judgment, and I quote, Seher, an order suspending internet services indefinitely is impermissible under the temporary suspension of telecom services, public emergency or public services rule 2017. Suspension can be utilized for temporary duration only. Point D of page 128, Seher, goes on to state, any order suspending internet issued under the suspension of rules must adhere to the principle of proportionality and must not extend beyond necessary duration. Point E goes on to state, any order suspending internet under suspension rules is subject to judicial review based on the parameters set out herein. So clearly the Supreme Court is of the opinion that internet clampdown indefinitely is something which is completely impermissible, and therefore this timeline that has now been set in motion by the top court's orders assumes a lot of import.
Yes, Meenakshi, we get that point. Please stay with us. Please stay with us. I'm connected with Dr. Abhishek Manu Singhvi, senior advocate, senior Congress leader here with us. Appreciate you being with us, Dr. Singhvi. In your view, to what extent this can translate into relief for people in Kashmir in the near future? Are we looking at this now being seen in a time-bound manner? Because the principle of proportionality that has been quoted in the Supreme Court, we can perhaps look at this being resolved in a lock-in period. It won't be indefinite.
I think it's a very timely, much-needed palliative. It is only the beginning. I think the spirit of the order, as much as the letter, has to be looked into and obeyed instantly. Proportionality is not a superficial, formal issue. In substance, don't try and fudge the issue. Don't try and, artificialize the issue. Tell the nation truly that you need en masse a detention of everybody who is in politics. Do you need a person to not have internet at all in the whole swathes of territory? I think this is the spirit of the order, and the government would be well advised to come down from the high horse, to have some humility, to have some responsiveness and not have an ego, and then solve the problem.
Right. Dr. Singhvi, also with respect to what has been mentioned in the Supreme Court today, this is on imposition of Section 144, that it can't be blanket across places for an undefined period of time. Do you think on what has been spoken in the Supreme Court today with respect to... Okay, yes.
I think that's a very important question. People take 144 for granted. It's the most well-known provision, most abused provision, and everybody thinks as if the moment you do 144, all democratic process was stopped. Actually, that is a complete subversion, inversion, and perversion of 144. 144 is that where there is act or omission showing a breach of peace, actual or immediately apprehending a breach of peace, then in future, in the basis of such legitimate apprehension, you can declare 144, which means people can't congregate. Now, what has happened in practice is that suppose 10 of us, you, me and 10 of us are going for a demonstration. It's a peaceable walking demonstration. We are making a point, we are carrying placards, shouting slogans, not a single violence, no provocative statement, no abuse to you, no insult to the people, nothing. Now what they do is, first of all, there is no basis for apprehension of peace being breached. Second, they first impose 144, and 144 imposition then creates the breach of peace. So 144 is imposed without reason. Then the people are stopped. People say, look, why are you stopping me? I am going in a peaceful demonstration. Then altercations and fights occur, and then 144 is justified. Suppose there was no 144, there would be no apprehension of breach of peace at all. So this is what is happening in practice, and I think it's very important that the time had come for the Supreme Court to put this warning clear. It's putting the cart before the horse.
No,
as I said,
Dr. Singhvi,
subversion, inversion and perversion of 144.
But Dr. Singhvi, in what you're explaining here, yes, but given that this was spoken only with respect to batch of petitions being heard for Jammu and Kashmir, would today's word in the Supreme Court regarding the imposition of Section 144 have an impact today on what we are seeing in nationwide protests against the CEA, on how 144 is imposed in certain areas, how 144 is imposed across entire states, or what we'd seen last month? Does this have an impact today in today's protests as well then?
Obviously. Please, obviously, the Supreme Court lays down law. It doesn't deal with just a particular instance. It is laying down the interpretation and law of 144. And let me tell you, if there is this very clear, strict approach to 144, even in a somewhat troubled state like Jammu and Kashmir, how much more it will apply to the rest of India? Much more so. There is no doubt about it. There is no basis for saying apprehension of breach of peace in large parts of India outside of J&K, where people are just doing peaceable demonstration. Thank you. I'll have to go. Thank you. There is also the Tata issue which you asked me about.
Dr. Singhvi.
Before I go, I must tell you, the Supreme Court has today... Hello? Hello?
Yes, please go ahead. We'll take that into account as well. Please complete your point.
Okay. Yeah. There was a question asked to me. Therefore, Tata issue, we are very happy. Since we are lawyers, we don't want to comment on the merits. We are very happy that the Supreme Court has, for the time being, completely 100% comprehensively stayed an incorrect, unsustainable judgment. If this judgment were not stayed, it would turn corporate law on its head. It would stop corporate governance. I appeared for the Tata Sons company, and fortunately, none of the various alternatives of interim stay suggested by the Mistry group were accepted by the court. They were not accepted. We have always said that we don't intend to use Article 75 for the present, and that was recorded by the court. But it is important to note that without a stay, there would have to be this absurd situation of majorities consulting minorities for appointments. There would be the absurd situation of appointments on boards as executive chairman and director, of prayers which had been given up expressly by the Mistry group. There would be absurd situations of impossibility to govern on a company with the leakages, with the backstabbing, with all kind of dangerous things. So I think this is an excellent order for the time being. Of course, it's an interim order. We have to argue the matter. And after 3-4 weeks, we will see what happens. Thank you.
All right, Dr. Singh, we appreciate you speaking with us here. Having spoken, of course, on the latter part of it with respect to the Supreme Court's decision on the NCLAT order on Cyrus Mistry, we're going to be discussing that later. But the issue at hand here for this hour, of course, is the Supreme Court's observations that have been made as far as the internet shutdown, as far as the imposition of Section 144 here in Jammu and Kashmir is concerned. Let's also get in another very senior legal voice, Justice Saldana, with us here on this as well. Appreciate you being with us. Your first reaction on what has been observed by the Supreme Court. Do you think that there is relief in sight for the people of Jammu and Kashmir because this is now going to be reviewed in a lock-in period of 1 week?
I don't think the Supreme Court could have passed a better order and a more timely order. And the reason for it is very obvious. First of all, there's absolutely no doubt about the position that the Supreme Court has now laid down, and this is the law of the land, this is the law of the country, namely that the Supreme Court has obviously taken cognizance of the fact that in today's world, you cannot exist without the internet. And that is the reason why the Supreme Court has said in so many words that the internet is virtually fundamental. It is a fundamental right, and it cannot be abridged except for very, very valid reasons. Sometimes there are grave emergencies. But that again can be done only for a very short and prescribed period of time. But the more important aspect of it is that if you want to abridge this right, you got to think of the consequences. Life gets paralyzed. Individual life, everything, business, whatever, it gets virtually paralyzed. And there's got to be very, very strong ground for doing this. And even if it is done, it has got to be done for the shortest possible period of time. Now, these are the principles which the Supreme Court has laid down, and I for one feel that there could not have been a better and a more timely order. I share the views of Mr. Abhishek Manu Singhvi, one of our really good counsel. But what I want to also add is that I was impressed by the fact that the Supreme Court has gone about the matter very, very courteously. They have said that, look, this is the principle that we are laying down, this is the law, now please act in consonance with it. The Supreme Court could have easily passed an operative order today itself, but they have not done it because they said we will give the authorities, both state and center, we'll give the authorities enough time and let them go about the whole matter and implement it nicely. So I don't think there could have been
and also for the orders to be published,
finer or a more nicely worded order. Yes. It's very important.
All right. Yes, please stay with us, Justice Saldana. We'll be getting in a voice here from Ground Zero.
Yes.
Very quickly, please stay with us. Going across to our correspondent Fareed with us there in Srinagar to get us in some first reactions on how people are viewing this on ground. Fareed, this is of course coming in from a place which has lived through the internet clampdown in the past 5 months, almost 5 months here. Is this being read as relief that could be brought to the people? Because the Supreme Court very strongly states that even access to the internet is your fundamental right.
Absolutely, Seher. It is a welcome relief because people here were beginning to think that people have India has forgotten Kashmir and what people are going through here right now, especially without internet. I mean, it was very clearly put by the Supreme Court. It's a fundamental right in today's day and age. And unfortunately, India has got this, should I say, bad distinction of being the only country where a place has been kept without internet for such a long time. Yes, law and order is an issue. It does crop up everywhere from time and again, and people do resort to, or administrations do shut internet, but that's for a brief period. You cannot go on with internet shutdown without any justification for 5 long months, and on the other hand, you contradict to your own orders by saying that everything is fine, normalcy is returned. Yes, normalcy is returned there is traffic, shops are opening, schools had opened, but then on the other hand, you say that you cannot restore internet because you still feel that there is something missing somewhere, and if you restore internet and you do not really back your own judgment. So this is contradictory from day one, and needless to tell you, we have been time and again saying that how people have suffered, how common man, students, business community, entrepreneurs have suffered, and they have suffered a lot. So this is a big relief, and hopefully post this, the government will have to at least justify why they did it for such a long time, because anything and everything just cannot pass in the name of national interest, because it's Kashmir. So anything they can get away with anything. So now at least a benchmark has been set, because let me tell you, Seher, normally it's a Home Secretary's order that is needed to shut internet, but in Kashmir, even a district SP, even a district magistrate, he would just pass on or send his orders to the mobile company, and they would shut internet. So at least a benchmark has been set, and now people have to be accountable for internet to be shut. But first of all, we'll have to wait and see what the state administration now decides, because 1 week has been given to them to review, and now people hope that at least broadband services, some internet will come back in their lives, and they can live like other people. I imagine the internet being shut in Delhi or any other place for a day or two.
Like
last time we saw how
1 week
people were up
waiting
in arms and
absolutely. That's right, Fareed. Appreciate you getting us that word from Ground Zero in Srinagar. It's a question of 1 week's wait, as opposed to what was seen as an interminable wait to have access to places with the lifting of 144 and to have access to the internet. Many thanks for getting us those details. I'm being told that we'll be going straight across to breaking inputs, a press conference that is being addressed from Mr. Manish Sisodia, Deputy Chief Minister of Delhi. Let's take a listen in.
हमने सबसे, और इसीलिए मैं दोनों मॉडल आपके सामने रख रहा हूं कि एक तरफ आम आदमी पार्टी का, केजरीवाल सरकार का मॉडल है, दूसरी तरफ मैं बीजेपी के मॉडल की भी बात करूंगा, बाकी पार्टियों के मॉडल की भी बात करूंगा। आम आदमी पार्टी के मॉडल में, केजरीवाल सरकार के मॉडल में हमने रखा कि हमने हैप्पीनेस कैरिकुलम इंट्रोड्यूस किया। हैप्पीनेस कैरिकुलम नर्सरी से 8वीं तक के बच्चों के लिए दिल्ली के सारे सरकारी स्कूलों में इंट्रोड्यूस किया। धीरे धीरे कई सारे प्राइवेट स्कूल ने भी इसको अडॉप्ट किया है कि जी हमारे पेरेंट्स ने डिमांड की कि जी हमारे बच्चों के लिए भी कराइए। ये कैरिकुलम अपने आप में इतना अद्भुत कैरिकुलम है कि इसके नतीजे 1 साल के अंदर अंदर पहले साल में ही आने लगे। बच्चे कहने लगे हमारा पढ़ाई में मन लगने लगा है, हमारा मन शांत रहने लगा है। हमने टीचर्स से पूछा बच्चों के अंदर क्या बदलाव हुआ है। टीचर्स ने माना कि साहब बच्चे अद्भुत चेंज आ रहा है बच्चों के अंदर, वो पढ़ाई पे ज्यादा फोकस करने लगे, अपना ध्यान लगाने लगे, जबकि उनका पहले ध्यान इधर उधर बहुत भटकता था। हमने पेरेंट्स से भी बात की, पेरेंट्स से चारों तरफ से बात हुई, पेरेंट्स से भी ये निकल के आया साहब बच्चे पढ़ाई पे भी ध्यान लगाने लगे और अपने परिवार में अपने माता पिता के लिए, अपने भाई बहनों के लिए बहुत इज्जत बढ़ गई है उनके मन में, उनके प्रति और संवेदनशील हो गए हैं। ऐसा अद्भुत कैरिकुलम कभी लॉन्च नहीं हुआ इस देश में। इसका लॉन्च करने का काम खुद दलाई लामा साहब ने किया है। हिज होलिनेस दलाई लामा साहब आए थे, उन्होंने इसको इंट्रोड्यूस किया था। इसके 1 साल पूरे होने के तक इसकी इफेक्टिवनेस इतनी ज्यादा दिखने लगी थी कि कई राज्यों के शिक्षा मंत्री 1 साल के उस पर यहां आए और स्कूलों में हैप्पीनेस कैरिकुलम कैसे इंट्रोड्यूस हो रहा है उसको समझ के गए। उन्होंने अपने यहां राज्यों में इस पे काम करना शुरू किया है। कम से कम आज 20 राज्यों के अधिकारी या शिक्षक या शिक्षा विभाग से जुड़े हुए और लोग हैप्पीनेस कैरिकुलम को आके समझ रहे हैं कि ये क्या है। बहुत सारे लोग इससे इंस्पायर होकर अपना बना भी रहे हैं, खुद बीजेपी समर्थित राज्यों के भी लोग बना रहे हैं। ये इसकी पावर है कि आम आदमी पार्टी कोई कैरिकुलम लेके आती है, कोई नई चीज लेके आती है अगर एजुकेशन में, तो वो ऐसी है कि उससे बच्चों के जीवन पे असर पड़ रहा है, परिवारों के जीवन पे असर पड़ रहा है, पूरे देश में लग रहा है कि इसको ये अच्छी चीज हुई है। अफगानिस्तान, बांग्लादेश, नेपाल से एजुकेशन से जुड़े हुए लोग आए। अफगानिस्तान और नेपाल के तो अफगानिस्तान और बांग्लादेश के तो एजुकेशन मिनिस्टर आए। उन्होंने कहा कि साहब ये ऐसी चीज है जिसमें हमारे देश में भी जरूरत है। खुद चीफ जस्टिस ऑफ इंडिया साहब ने कहा कि ये हैप्पीनेस कैरिकुलम ऐसा है जिसकी सबसे ज्यादा जरूरत हमारे कोर्ट्स में है, हमारे जजेस की ट्रेनिंग में है। उन्होंने कहा कि अगर हैप्पीनेस कैरिकुलम ठीक से लागू हो गया तो आप तय मानिए कि हमारी अदालतों में मुकदमे कम होते चले जाएंगे। ये टिप्पणियां हैं जो आपने भी सुनी है बीच बीच में। मैं इसलिए रख रहा हूं क्योंकि एक तरफ ये मॉडल है कि एक आम आदमी पार्टी सरकार बहुत साइंटिफिक रिसर्च करके, बहुत वैज्ञानिक तरीके से बच्चों के विकास के लिए कैरिकुलम लेके आती है। दूसरे मॉडल पे बात करने से पहले मैं दूसरे इंटरवेंशन की भी बात करना चाहूंगा। दूसरा हमने इंटरवेंशन किया जो और महत्वपूर्ण माना जाता है, एंटरप्रेन्योरशिप माइंडसेट कैरिकुलम। इसका मकसद है, दो मकसद हैं इसके। पहला मकसद है कि हम पूरा देश बेरोजगारी से जूझ रहा है, एंटरप्रेन्योरशिप माइंडसेट कैरिकुलम। पूरा देश बेरोजगारी से जूझ रहा है, हर तरफ पढ़े लिखे नौजवानों की जमात खड़ी हुई है। दिल्ली का मैंने आकलन किया, हमने देखा कि 2.5 लाख बच्चे हर साल दिल्ली के स्कूल पास करके निकलते हैं। इन 2.5 लाख बच्चों में से अगर हर बच्चा नौकरी ढूंढने के लिए निकलेगा स्कूल कॉलेज से, तो फिर नौकरी देने वाले कहां से निकलेंगे। इसीलिए हमने निश्चित किया कि हम अपने स्कूलों में 9th, 10th, 11th, 12th चारों साल बच्चे को एंटरप्रेन्योरशिप माइंडसेट की क्लास लगाएंगे और रोजाना लगाएंगे। हैप्पीनेस की क्लासेस भी रोजाना लग रही है, एंटरप्रेन्योरशिप की रोजाना लग रही है। और इसका 1 साल का ही अभी तो पूरा साल भी नहीं हुआ, इसके नतीजे भी इतने शानदार हैं कि मैं बच्चों से जाके पूछता हूं, पेरेंट्स से पूछता हूं, टीचर्स से पूछता हूं। टीचर्स कहने लगे हैं कि बच्चों के मन में नए नए बिजनेस आइडियाज आने लगे हैं। उनके मन में आने लगा है कि हम अपने फैमिली बिजनेस को सपोर्ट करें। मैं एक स्कूल में गया, वहां पे एक बच्ची ने मुझे बताया कि सर मेरे पापा का बिजनेस नीचे जा रहा था, लेकिन मैं कभी ध्यान नहीं देती थी। जब से एंटरप्रेन्योरशिप कैरिकुलम लागू हुआ है, मेरे भाई ने और मैंने मिलके, क्योंकि एंटरप्रेन्योरशिप मेरे माइंड में आया।
Manish Sisodia, Delhi Deputy Chief Minister there, talking about all the reforms that have been undertaken by the Delhi government in Delhi government schools. This is with respect to happiness curriculum and why it's important, and also now having added entrepreneurship curriculum here to deal with the market once you step out and completing your education. This is, of course, also in comparison to what the AAP government model has been vis-a-vis what the BJP has spoken about. In other news, this is in a case from Delhi which dates back to 2016. The Supreme Court lately ruled that the killer driver who ran over an IT professional who died because of this will not be tried as an adult. The accused was 4 days short of turning 18 at the time of the accident. The victim here, the person who lost his life, 32-year-old IT professional Siddharth Sharma, was mowed down by a speeding Mercedes in Delhi's civil lines area while he was trying to cross the road. Earlier, 2 courts in the Juvenile Justice Board and the Sessions Court in Delhi had called for the accused to be tried as an adult. The top court, though, passed the order, observing that there is an unfortunate gap in the law. Let's get in further details. I have with us my colleague Tanima with those inputs here. Tanima, help us understand with respect to the observations of the Supreme Court in saying that there is unfortunate gap in the law because there was a juvenile justice amendment that came in a year before the accident, which was 2015, which allowed for juveniles aged 16 to be treated as adults, keeping in view the nature of the crime.
That's right, sir. In fact, let's just quickly look at the observations made by Supreme Court while passing that order. As we said, 2 courts earlier had recommended that he should be tried as an adult. What did the Supreme Court say? So the Supreme Court said how and in what manner a juvenile should be dealt with is something that the legislature should have clearly spelled it out. So clearly, again, pointing over here that there seems to be some gap in the current law, which is in a way holding the courts back from passing a more stricter judgment when it comes to this grey area, whether or not a person crime should be the measure as to whether a person, an accused, could be tried as a juvenile or an adult. The next point, very clearly spelling out, the Supreme Court says there is an unfortunate gap in the current law. Of course, talking about the juvenile justice law in its present format. If we go into the next point there, the Supreme Court says we cannot fill the gap, saying these offences should be treated as heinous offences. So essentially, when that argument is put up in court that because a particular crime is a heinous offence, the person who's committed it should be tried as an adult, despite the fact that they may not have reached that age of 18. So in this case, whether or not it should be the court's discretion to treat that person as an adult, that still seems to be a grey area. And as far as law is concerned, and in sticking to the spirit of the law, Supreme Court had to say that we have to treat the accused as a juvenile. Scheme of Juvenile Justice Act at the moment in India is that children should be protected. And the last point, if we look at, where the top court says treating children as adults is an exception to the rule. So as we know, Seher, that there are countries like Australia or other countries in the world in which there have been cases of juvenile being treated as an adult depending on the gravity of the crime. But in this case, of course, the Supreme Court clearly saying that the law, there seems to be a gap in the law which is preventing the courts from using their discretion in such matters.
All right. Tanima, many thanks for explaining that to us. And given the fact that this is the Supreme Court, the apex court, telling us that there is an unfortunate gap in the law, this despite the fact that there was an amendment to the Juvenile Justice Act 2015. In this instance, when a life has been lost, but the main accused has been let off because he was 4 months short of being 18, even though he was fined thrice before for driving high speed. We'll have to leave it at that. Thanks for being with us.